Good day everyone, welcome to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I'm VP Moolman from Maserumule, and in today's episode we will unpack what if a foreign national's work permit expires. Can an employer continue to employ the employee? Now, as a departure point, let's look at the applicable legislation governing foreign nationals in South Africa. The employment of foreigners in South Africa, colleagues, is regulated by the Immigration Act. The Immigration Act provides for the admission of foreigners to, their residence in, and the departure from South Africa, as well as matters connected therewith, including the ability of foreigners to work in South Africa. Furthermore, the Employment Services Act regulates the employment of foreigners. However, I will be referring mostly to the Immigration Act and specific sections thereof. Section 38 of the Immigration Act provides that no person shall employ an illegal foreigner, a foreigner whose status does not authorize him or her to be employed by such a person, or a foreigner on terms or conditions or in a capacity different from those contemplated in such foreigner's status. Importantly, in terms of Section 38, subsection 2 of the Immigration Act, a duty is placed on an employer to make an effort in good faith to ensure that no illegal foreigner is employed by it and to ascertain the status or citizenship of the persons in its employ. Furthermore, Section 49, subsection 3 of the Act provides that anyone who knowingly employs an illegal foreigner or a foreigner in violation of the Immigration Act shall be guilty of an offence and liable to a fine or a period of imprisonment not exceeding 1 year for a first offence. Now, from what I have mentioned, it is evident that the Immigration Act prohibits employers from employing a foreign national in violation of the law. But the question is, if you have in your employ a foreign national whose permit or work permit expired, can you continue employing him or her? And if not, how does one go about terminating the relationship? In other words, how does one go about dismissing the employee? Now, in discussing this question, we need to first consider whether the Labour Relations Act applies to foreign nationals who are not legally allowed to work in South Africa. This is important because, as you are aware, the Labour Relations Act requires employers to, before dismissing an employee, specifically a permanent employee in this case, to have a valid reason to do so and to follow a fair procedure. Now, one might think that if a person is not legally allowed to work in a country, the employment laws of the country can no longer apply to this person. But in South Africa, this is not the case. In short, in South Africa, a foreign national whose work permit expires whilst employed, or who is employed without a relevant work permit, is still an employee for the purposes of the Labour Relations Act. This means that the employee would have recourse to compensation in the case of an unfair dismissal through the CCMA. But such employees would obviously not be entitled to a reinstatement, as such an order would be in contravention of the Immigration Act. Now, colleagues, because the Labour Relations Act applies, irrespective of the status of the employee's permit, if an employer wants to terminate a contract of employment of a foreign national because his or her work permit expired, such termination or dismissal must be fair. And in terms of fairness, and as we've mentioned, the Labour Relations Act requires the employer to have a valid reason to dismiss, and the dismissal must be preceded by a fair procedure. In the case of foreign nationals' permit expiring, the question is, what is this fair procedure that one should follow or be following? In discussing the process, colleagues, I will be referring to a foreign national who is employed on a permanent basis and not on a fixed term or temporary basis. Some employers employ foreign nationals on fixed term contracts, and the term of the contract is linked to the validity of the employee's permit. In the event that the fixed term employee's permit expires, the contract also expires. However, if the employee is employed on a permanent basis, I suggest the following process to be followed. So, as soon as the employer becomes aware that the employee's permit has expired, the employee should be informed, preferably in writing, of the following. Number one, that the employer is prohibited by the Immigration Act from allowing the employee to tender his or her services. Number 2, that because of this, the employer is temporarily released from its obligation to provide the employee with work and to remunerate the employee accordingly due to the impact of the Immigration Act, as it renders it impossible for the employee to perform in terms of the employment contract. Number 3, or thirdly, that the employee's employment contract with the employer is not being terminated, but that the terms and conditions thereof have been suspended pending the outcome of the employee's new application. And because of this, the principle of no work, no pay will be applied. Now, also where applicable, colleagues, this is not always the case, but the employee should also be informed that the employer has no obligation to maintain fund payments and or external funeral benefits, and that same will be recovered at resumption of duties if the employee resumes the duties. Number 4, the employer should inform the employee that it or the employer has a duty to take the necessary and reasonable steps to assist the employee with his or her new application. In this regard, the employee should be informed that in order for the employer to be able to assist him or her thoroughly, the employer is requesting that he or she advise the employer of things such as the steps that he or she have taken so far in making the application for the new work permit, the contact details of any authorized person whom the employer may contact with the intention of expediting the process, and perhaps also any reasonable recommendations and or suggestions that the employer may implement, which the employee may deem necessary in order to assist the employee in acquiring the new work permit. So colleagues, over and above informing the employee of these 4 points that I've just mentioned, the employer should also provide the employee with a reasonable period to obtain a new permit, and should inform the employee of this period. The employer should further be informed, or the employee rather should further be informed that should he or she fail to obtain a permit within this period, the employer will have no other alternative but to terminate his or her services as a result of the employer's operational circumstances. Now, colleagues, should the employee's application be approved and or granted within the period, the employee's contract will simply be revived and he or she can resume their contractual duties. But if he or she, the employee, is unable to obtain a permit, renew it, extend it, etc., the employee's services cannot continue, and the employee will in all probability be subjected to a hearing process, at the end of which his or her services may be terminated. So in essence, colleagues, the process I refer to primarily involves the suspension of the terms and conditions of the contract until such a time the employee can prove that he or she has a valid work permit. During this period of suspension, the employee is not paid. The employee is provided with a reasonable period to obtain a permit, and if he or she fails to do so, the employer may terminate the contract following a hearing. So in conclusion, colleagues, the Immigration Act prohibits employers from employing foreign nationals without valid permits. That's quite straightforward. The law clearly places the onus on the employer to comply with the relevant legislation, and it holds the employer liable, not the employee, it holds the employer liable for non-compliance. A foreign national whose work permit expires enjoys protection under South African employment legislation, and accordingly, employers wanting to terminate or dismiss a foreign national must do so fairly. That brings us to the end of this week's episode. Thank you for joining us. We hope you found our discussion informative. If you have any questions or comments, we would love to hear from you. As always, you can find us on social media, or you can email me at vp@massconsulting.co.za. I'll see you next time. Bye-bye.